Beal and Sydney Page Simon. It's case number 2023 DM 300003. I will note that Mr. Perez Beal appears along with his attorney of record, Ronald Wood. Sydney Simon appears separately from her attorney of record, Lauren Schuler. This matter comes before the court at this time for further proceedings. Counsel, this court had conducted a trial in this case, made rulings and orders which should be journalized by now. As far as I know, the court does not have a journal entry of judgment and decree of divorce submitted as of this point. I also note that Mr. Wood has moved to withdraw his counsel for the petitioner in this case, which has actually been objected to by the opposing party. So I'm going to start with Ms. Schuler and ask her, where are we at on this case?
Thank you, Your Honor. So did you receive my exhibits?
I did.
Okay. So I did draft a journal entry. The proposed journal entry is Exhibit A. I did supply the email that I sent the journal entry, showing that I sent the journal entry to counsel Mr. Wood. I sent that on Tuesday, May 13th. As you stated, we did have trial on May 7th. I did supply as well, which is reflected in the court filing, Exhibit C, which is Mr. Wood's objections. If you look at the objections, Your Honor, unfortunately, a majority of them are not actual legal objections. They are essentially requests to change your ruling. And I can go into further detail, but I would argue 80% of them are just requests to change your ruling. They're not actual legal objections. And I think that's where we're at a standstill. I was waiting on this hearing.
What about the other 20%?
I did make
corrections
those.
that are appropriate?
I did make them.
Okay.
So specifically objection 1, 3, 7, 17, and partially 14 were all made. Missing a comma or referencing specifically the parties for joint legal custody. I did make those. But outside of that, the others are requests to modify your ruling. So I was waiting on this hearing to file a motion to settle the journal entry. So that's where we're at on the journal entry. I will wait to go over my objection to the motion if you would prefer that.
Welcome back, everyone. In today's video, we're breaking down a courtroom clip originally posted by a channel called Looking at Legal Stuff. They're a smaller but solid legal content channel, and after watching this video, I'd encourage you to check them out and support their work. The case itself involves a divorce proceeding where the husband is unhappy with how things are going, that he wants to dismiss his attorney, represent himself, and challenge nearly every decision the judge has already made. Standing in his way is a judge who stays focused, firm, and largely unmoved by repeated interruptions. Let's dive in.
All right, Mr. Wood, as far as the court's concerned, the court wants to settle this journal entry before allowing you to withdraw. I do understand the nature of your motion in this case, but I do note that on behalf of your client, you filed certain objections back on June 3 to the wording of the proposed journal entry of judgment and decree of divorce. Some of these cosmetic changes have been made, apparently. I understand that your client may not be 100% in agreement with the court's ultimate rulings in the case, but what this journal entry is intended to do is to simply document what the court did rule upon. So what's the problem here, Mr. Wood?
Well, Your Honor, I received from my client approximately 4 pages of changes that he wanted to make in the journal entry. I took those at the best I could and made those objections known to the court the best I could that would not be considered frivolous or completely not allowed in this type of a review of the journal entry. So I did what I could, and then once I did that, then I received wording from my client that he was did not approve of what I have objected to and wanted to know why I didn't use everything that he'd given to me as objections in the journal entry. So I did what I could to pare it down. What really concerned me, though, also is that I filed that on June 3rd, but on his what he had sent back to me, objecting to what I'd sent, he'd start sending copies of that to the disciplinary administrator. And so that concerned me whenever the disciplinary administrator gets involved and indicates that, she didn't want to be involved with that. So I understand the court's position on withdrawing, but I had to put forth the objections that my client in some manner objected to with the understanding that I think some of his objections really would be more of a motions for rehearing or motion for modification. And that's a little bit of a problem when people are using the internet or whatever they're using to come up with attempting to practice law. And so they don't understand the distinctions between those and the objections to the journal entry. The journal entry is supposed to recite what this court had ordered. And it's not to be the objections to what the court had or whether you agreed or disagreed with what the court ordered. The journal entry is to reflect what the judge ordered. And whenever I get something saying, no, these are all the objections I have to the journal entry, and I'm sending these copies of all this to the disciplinary administrator, that concerns me that I've got someone, watching over my shoulder. He doesn't trust my abilities to do the work that I'm doing, doesn't understand with 46 years of experience that I know what I'm doing.
At the heart of the issue, the father disagrees with the court's earlier rulings. He believes that filing a motion to revise the court's journal entry will somehow reopen decisions that have already been made. The court agrees to review the concerns point by point, but only within proper legal limits. To be fair, there is at least one narrow issue worth discussing. Some language in the journal entry could reasonably be interpreted as unclear or overly broad. However, before addressing that argument, the court must first handle the attorney's formal request to withdraw from representation.
But if he and I cannot communicate, if he continues to think that I'm not doing a job for him, then I just figured I had to withdraw, Your Honor.
All right. Ms. Schooler, I'm going to go back to you for a moment. I trust that there's been some personal communication between you and Mr. Wood in an attempt to try to reconcile differences on the wording of the journal entry, perhaps a recent phone conversation or email chain or something?
I did call Mr. Wood. I did let him know I was going to have to object because we were still in the process of working out this journal entry. You did order for some documentation to be provided to me by petitioner in regards to picking a vehicle. So I said, hey, get me that. We did not go into the journal entry as much. I did let him know, hey, I made some of the cosmetic corrections, but your objections or your client's objections are, again, more so for reconsideration, and I'm not going to make those changes. And that was after our Exhibit D, the email including me and Mr. Wood with the disciplinary administrator, where Mr. Presbeal says he is going to file an ethics complaint against me. So not as much as I'm sure the court would prefer, but obviously with this email coming out, I believe Mr. Wood was trying to be as cautious as he could due to the situation.
All right. So the first issue before the court is settlement of the wording of the journal entry in this case. And in doing so, I'm going to try to systematically go through here and determine, is there a legitimate objection to the wording used by Ms. Schooler in what I see as, I want to make sure everyone's on the same page as to what I'm referring to. In my exhibit notebook, it's Exhibit A, which is what I believe is Ms. Schooler's most recent attempt to draft an appropriate journal entry of judgment and decree of divorce. Is that correct?
Yes, it is, Your Honor.
All right. Obviously, the comma in number 1, it's been resolved. Petitioner objects to the court's finding, and the petitioner will not respect the bond of the respondent. Oh, to the extent, apparently, that the petitioner will not respect the bond of the respondent in this matter. If that's consistent with a ruling from the bench, and I think it is, then
Your
that's
Honor.
not objectionable. Okay.
May I make a statement?
Mr. Perez-Beal?
Yes, sir.
So-
That's me.
What's your statement?
My concern here is several things in the journal entry are not written how the court ordered. I have recently filed for a transcript request for the judgment in this case. I've paid for that and I have a receipt for it. And a lot of the wording affects the legality of the court's judgment. And when it comes to getting involved with disciplinary administer, I done that because Mr. Woods failed to address our son getting bit by a dog while in his mother's care, failed to address Sydney not showing up for
Okay, we're
exchanges
getting off the
of
path
order
here.
twice.
We're
No,
getting,
sir, we're not.
okay. All right, regarding number 2, the court will overrule any objection to this finding. Mr. Simon's actions in, as I recall, taking possession of the child at a bus stop, that alone gives this court pause and some reason to make a finding that the court has concern that Mr. Perez-Beal will not respect the bond of this child with his mother.
That was during my
And there are other
parenting
reasons. However, the court finds that the objection is overruled as to number 2. Number 3 apparently has been corrected. As the court recalls, there was a protection from abuse case previously between these parties. The court finds that even though Mr. Perez-Beal may deny that there was ever any abuse by him, the court does find that that's an appropriate finding for the court to make. And the court will
Point of
overrule the
order.
objection to number 4. The court also finds that there has been difficulty between these parties based on the evidence to effectively communicate regarding setting a parenting plan or deciding many important matters concerning this child. So the court does
I'm
find that there's
submitting all of our
evidence in the
text
record.
messages.
All right, if you interrupt one more time, Mr. Perez-Beal, we're going to mute you or take you out of the meeting completely.
Yes, sir.
This is where the situation starts to unravel. The idea that decades of legal experience can be replaced by brief online research quickly becomes apparent. The court makes it clear that professional training and real-world courtroom experience matter. TO understand how we reach this moment. A bit of background is necessary. The husband was previously arrested on charges related to his spouse, and during sentencing, he expressed hope for reconciliation. However, a divorce hearing took place while he was in custody, which he did not attend, and by the time he was released, the marriage was already legally over.
So the court does find that there's evidence in the record to support that finding of number 5. Objection number 6, objecting to paragraph 13 in the school district should be USD 232.
Your Honor, just so you don't have to pull up the, Google it, USD 232 is DeSoto, Kansas, which is
Okay.
up towards Lenexa.
282.
All right, so number 13.
A lot
West
of the
Hill Schools,
objections-
why is that a problem?
A lot of the objections he made are not what I requested, and I'm getting ready to submit that,
All right.
what I have requested to him.
Okay, I think the children do attend West Elk schools, correct?
Yes.
They
Yes,
do.
sir.
Okay, so what's improper about 13? I
He
don't
has
see any
manipulated my
problem there.
objection request.
Okay. I don't think we need to put the USD number in there. I think the term West Elk Schools is specific enough. I'll overrule any objection to 13. Number 7 apparently has been corrected, Ms. Schooler.
Yes, it has been.
Paragraph 26.
Yes, I did make that correction.
All right. That appears to be consistent with the orders and rulings of the court as it currently reads. Objection 8. Is there some dispute about the amount of child support to be entered into the record here?
Yes,
Yes.
sir. There's been 3 child support worksheets entered on this without a chance for me to do taxes and submit financial records. And her most recent one states it was filed in, I believe, June 13th
Okay, well,
or May 13th.
okay, wait a minute. Let's back up. Mr. Wood indicated in his objection that I ruled from the bench that I was specifically adopting a particular child support worksheet that called for an amount of $1,383. So why wouldn't that be appropriate, Ms. Schooler?
Your Honor, because you did not adopt a specific worksheet, we imputed Mr. Presbeel's income at $58,000. I think $230. I might be off on the last few dollars, but he was
58,320.
imputed. Correct. And I had to make the tax adjustments, so there was no actual worksheet adopted because I had to make a change. But he was imputed by you, or his income was ruled upon that it needs to be imputed. So the February 12th worksheet does not have the imputed income because we were never provided that information.
There was never no paperwork filed to omit the previous child support worksheets that were submitted with a file stamp.
Judge Rickey runs a tight courtroom. Throughout the hearing, he does not allow unnecessary interruptions to derail the process. When questions wander off course or statements drift into argument, the judge calmly moves forward without engaging. This approach keeps the hearing structured and efficient. Rather than reacting to every comment, the judge focuses on procedure and legal relevance. It's clear that patience does not mean tolerance for disruption.
One of them by Miss Simon herself with a self-litigant form that she submitted with it. And Your Honor, I'm getting ready to file a motion and lay out a lot of things that have gone on here that I believe Miss Schooler and Mr. Woods are discussing and kind of having backroom conversations. Mr. Woods' motion to withdraw on our inability to see eye to eye on this is false. I use a phone recorder, and Mr. Woods previously told me, I believe it was the 10th, that he demanded $7,000, and if I didn't pay, he was gonna withdraw.
All right.
So,
Okay,
extortion.
I'm really just focusing on the child support worksheet, one issue at a time. I don't see your proposed worksheet, which calls for that amount. Ms. Schooler, it doesn't appear to be an attachment to your journal entry.
What about the one the respondent
Okay,
filed
Mr. Presbeel, be quiet for a moment.
December 20th?
I'm addressing Ms. Schooler. The worksheet that you're depending upon to justify your amount in your proposed journal entry, which is a couple $100 a month higher than what Mr. Wood's objection stated it should be. So where is your worksheet?
Your Honor, I believe because that wasn't a legal objection because you already had ordered for his income to be imputed. I didn't include it, but I am going to pull up my notes from the hearing that I have right here.
Well, that worksheet would need to be filed with the decree.
Right. Because you had already ordered for his income to be imputed.
True.
And
What the
changed
court often does, counsel, is to set the building blocks necessary to put the worksheet together. I hope to always settle those building blocks without determining the actual amount. That really is a mechanical computation. Once you know what to plug in, essentially the worksheet software does it from there. So I don't fault you in all respects here, Ms. Schooler. It's just that whatever worksheet is eventually generated based on the building block orders that this court has made, that needs to be included to support the child support amount, which is in the decree of divorce. But you're telling me that once you had adopted all the income numbers and put all the proper inputs in, it came out at $1,569 a month?
I do believe so, Your Honor, yes. I'm going to try to find it in what I sent to Mr. Wood.
And I may have adopted certain numbers out of a child support worksheet that had been submitted. But I think if there were any adjustments that needed to be made to the worksheet for any reason, tax exemption adjustments or anything, then I couldn't have settled or finalized the child support number at the hearing.
No,
That's why
you wouldn't have been able to,
requesting
Your
a
Honor.
transcript.
Because you will see in the my proposed journal entry, you specifically stated, I'm going to find that paragraph for you, that his income must be imputed at that number because he had not provided any income information, and you felt that that was a good number for his trade skills, the kind of work that he does.
Imputed at what number?
$58,320.
That's what your child support worksheet says, but it says date submitted May 13th. The one you submitted on February 12th says $13,833, and on the child support worksheet the respondent submitted December 20th of 2023 states where we agree on no child support at all. I'm
None
all
of those
for
past
taking care
worksheets
of
mean a
the
thing right now.
children.
What the court's concerned with was what was presented to the court at the trial and what numbers this court ordered be put into a child support worksheet to generate the eventual child support amount.
Your Honor, it's
I believe it was the
29.
one
Okay,
from
just a
February
minute, Mr.
12th.
Presbeal. Again, Ms. Schooler, you have the floor.
Paragraph 29 of my Exhibit A is where I reference you imputing the income, what you imputed at, and why you imputed it that way.
All right. Well, again, Ms. Schooler, it's just difficult for the court to adopt a worksheet number when I don't have the worksheet.
I do apologize about that.
But presupposing that you do have a proper child support worksheet, which places the numbers in that was found by this court to be appropriate at time of trial, if that's how it comes out, that's how it comes out. Now, what did you do with the tax exemption benefits, Ms. Schooler? What?
Your Honor,
What did
he
you
was
contemplate?
given a $203 credit because my client would have been able to claim all three children for the year 2024. There is also a daycare cost in the amount of $500 that my client pays. So father was imputed $500 for childcare, and then he was given a complete income tax credit for all three children.
Mm-hmm.
On the numbers per age on children, you have two children between the ages of 6 and 11 and one under the age of 5 or 0 to 5. Right now, at the time of this document, we have two ages 0 to 5 and one age 6 to 11. And where is the $500 child care? Where can I find that, Ms. Schooler?
Your Honor, do you want me to try to sort this out? I just don't want to.
Is it included on the proper line?
Yes, it's in paragraph G1 on the worksheet.
Okay.
And for the child support guidelines, when the child is over 6 months or close to 6 months, they
what you have.
to the next age group. So I can't control that.
All right. I'm aware of that provision, counsel.
Your Honor, may I have time to file the past 2 years' taxes that a previous attorney told me to wait until this issue was resolved to file my taxes?
No.
Yes, sir.
We're settling today's journal entry based on what was presented and ruled upon at the trial of this matter.
I'm objecting to the journal entry being finalized today.
Well,
Much of the husband's argument centers on technical objections to court paperwork. He suggests that missing stamps or filing errors invalidate prior rulings. The court responds by explaining that official records are presumed valid unless proven otherwise. most of his objections ultimately come down to dissatisfaction with wording. Legal language can be precise and sometimes complex, but that does not make it optional. The judge emphasizes that challenging phrasing requires clarity, preparation, and effort, not frustration.